The corporation of courts have laid a minefield of tricks and traps for the unwary, uninitiated, and the ignorant pro se litigant who dares trespass into the monopolized realm of the state courts. In this segment, we'll speak about Texas. By skillful and manipulative use of the rules of the court and judicial interpretation of the rules, the lawyers, with the complicity of the judges, are able to get their hearsay evidence entered into the record as facts and deprive the ignorant pro se litigant of his evidence. When the other side can get whatever they want, including hearsay, admitted into the record as evidence, and the pro se litigant cannot get anything entered into the record as evidence, the outcome is obvious. You cannot win without evidence to prove your case. One might say, this doesn't seem to be fair or in the interest of justice, but fairness and justice has nothing to do with the operation of Texas courts. The pro se litigant is expected and required to follow the rules. In Texas courts, the pro se gets no slack. Let me quote, "A party acting as pro se must comply with substantive law and procedure rules," end of quote. That's in Henry Caldwell, 1995, 918 Southwest 2nd, 9 and 10. If one is ignorant of the rules and of how the corporations manipulate the rules, the corporations will invariably strip you of your property, steal your children, or throw you in prison, or all the above. But in the eyes of the court, they've done nothing wrong. You should have hired an attorney, they will say. However, the final outcome may well be the same if you had. Even if the litigant wins with the aid of an attorney, often the only difference in the final outcome is that the attorney, not the adverse party, ends up with all your money and property. In either instance, you will have been impoverished and reduced to a pauper by the Texas form of justice. You can win, but still be the loser. Now one might say, how do attorneys' unsworn statements become facts of evidence? And what do I do to prevent it? You see, the trial court has the discretion to admit or exclude evidence. The appellate court will reverse only on the abuse of discretion standard. If the trial court sustains the objection, it will not admit the evidence. The party who offered the evidence still has other options that it must exercise, or it waives the error. An attorney's unsworn statements are not evidence. See U.S. Gov. versus Marks, 1997, 946 Southwest 2nd, 326. However, on appeal, a lawyer's unsworn statement can be considered evidence unless the other side objected at the trial. See Banda versus Garcia, 1997, 955 Southwest 2nd, 270 and 272. If you want legal advice, hire an attorney if you know of a competent one that you can trust and afford. Otherwise, do your homework. We'll come back with part 2.